What are the implications? Okay, so if I start by knowing from you, what is your idea about, or what information or knowledge you know about intellectual property or copyright? So if you are able to use the link that I put in the chat, or if you managed to scan the code that I put earlier, if you could think about it and then maybe answer the question. Do you think that they are the same or different when we talk about copyright, IP, or you either not sure or you don't think it applies? What do you think? And it's your opinion, it's not what other people think, isn't it? So we'll see how many more people will participate. So feel free to put in your answer. Because we hear about a lot, isn't it? Intellectual property, copyright. What do we think? Okay, I'm just waiting for more people to be able to participate. So the link is in the chat. If there's an issue, then let me know, but you can use the link in the chat to put your answer. Okay. Okay, so we'll cover in a minute what we talk about when we talk about copyright and IP. But if you came across a copyright statement or a sign, where do you usually see it, or have you ever faced that? Anyone would like to maybe type in the chat, or you can unmute yourself and say. So have you seen something that indicates that the material that you're using has they have copyrights, or they're protected by copyrights, for example? Anyone? You can type in the chat if you wish to. Okay, so we can show in a minute examples about it. Yes, we have books covered by copyright. Some of the websites, you can see them. You can see signs where at the bottom of the website says it's copyright protected. Movies, yeah. So artwork protected by copyright. Okay, so if we come back to the question about IP and copyright, okay, thank you. Yeah, videos, thank you. That's so. If we think about intellectual property, so this question is a bit kind of tricky of me that I put it that way, but they're not the same. But copyright is part of intellectual property protection. So when we think of intellectual property, we think of patents and other things. So intellectual property as a general term, it is a way to protect someone's creation. So as you said, for example, if it's written materials, books, if they are artwork like movies, plays, poems, artwork in terms of visual artwork, so drawings or photographs, all of these can be protected. They have intellectual property protection. Someone generated them and they can have a protection. So copyright is part of the intellectual property. Also patents, trademarks, registered designs, they all are intellectual property, and they give that protection to the owner or the creator of that work. It's just that the differences of what type of protection it gives and whether or not it's something that you need to apply for and to get it. So probably most of us are aware of patents, that it's something that you apply for and it's expensive, for example, to get it. So for every region, there is governing body or part of official body that is responsible for implementing the protection for intellectual property. For example, in the UK, it is the Intellectual Property Office. So it is the official government body responsible for IP rights. So it's important to know that protection in one region does not necessarily automatically grant protection in another region, especially for example, for things that you would register for. That's an important element. Okay, so if we talked about that intellectual property, people have to, or the creator need to apply for it. Which type of these intellectual properties do you think someone has to apply for to get the right? Not necessarily that just by creating it, it becomes, they get the right, they have to apply for it. What do you think?
Now, who is this talking that I don't understand your English? Let me get my...
Okay, so if more people would like to think about this and maybe try to answer, the link is in the chat. So we talk about that you have to get your right to protect your creation, whatever that is. Do you need to apply for all of these if you want to have that protection? So as you said, for example, in the UK, there's Intellectual Property Office. Do you have to apply for it to get protection in all of the different types of intellectual properties rights? Okay. Okay, I think based on the answers might be interesting for many of you to know that. Okay, just wait for a couple of people to maybe to apply. So the link is in the chat, the first part of the chat. So feel free to click on it and vote. Because it's really interesting to see what people think of different types of protection, IP protection. Okay, right. So as I said, it's like probably will be interesting for a lot of you to know that copyright, you don't need to apply for it to get a copyright of your creation. So because these protect different things, and copyright protects anything that you generate. So for example, if you have photographs or artwork, by just creating it, you have your protection. You don't have to apply for it. So the copyright is something that it's a right that gives you protection of your work, so no one else can use it without your permission. And in the UK, you don't need to register for copyright. It's an automatic protection. As we said, you've probably seen the symbol that is C. So probably now you scrolled whenever you visit any website, you can scroll down to the bottom of the website, the bottom of the page, and then you can see that it puts the symbol for the protection for the copyright. But it's something that you don't have to apply for it. You don't pay any fees to get the copyright in the UK. So whether you put that symbol or not, you're protected for that. Sometimes this protection is limited, or it is limited by time. It just the duration differs between the type of the work and also the country. So some type of work can be protected for say 50 years or plus 20 years for different type of protection. So it's an important thing. So if you created a website, it's yours. You have the copyright for it. You don't need to apply for anything to protect it. It's important to know if you sign, if you give away your copyright. So and it is important for publishing. So if you write a book or a part of a book, so a book chapter, as there will be a copyright agreement with the publisher. So a lot of publishers might have assign the copyright for themselves. So, and it's something interesting, you didn't know until you be part of it. A lot of the textbooks that you probably see in your libraries, for example, pharmacology books or pharmaceutics or anything, you can look at it and you see that the copyright is belonging to the publisher. And it means that the authors who wrote part of the book, they don't have the copyright. They can't reuse any materials without getting the permission from the publisher. Even though they created the work, they wrote the chapter or the book, but because they given away the copyright to the publisher, they no longer have it. It's a similar thing when writing publication for in peer-reviewed journals. So if you know that there are two different kind of types of how the materials or the publications are available for the public or for use, is a subscription way, and there is the open access way. So with a subscription model, which probably you know, it is that there is a paywall, so you have to subscribe to have access to the articles. And usually in these cases, it's that the publisher, the owner of that journal, has the copyright. So the authors, they don't have a copy, they don't have the right for the journal, even though they are the ones who have done the work and they've written the paper and submitted it. It's very interesting research publication for scientific research. So as an author, you can't just simply put a copy of your paper on your own website, because you don't own the copyright, it's owned by the publisher. So there's what the move has been for the last few years for open access, where there are either journals who are fully open access, and in that way, the publisher, which is that owns the journal, does not have the copyright. The copyright is with the author, but the author or the authors, they have to pay to have their research or publication open access. So there's no restriction. The user can you can go on an open access journal and you can have access to any publication without without subscription. So you don't have to pay, or your institution doesn't have to pay for you to have the access. So that's the open access system. But someone has to pay, and it is the author or the institution where the research happened, and that's where they pay for it, and they retain the copyright, so they can reuse and distribute the materials. There is a way to something which is called the Creative Commons license, and that is something that you can use. You don't need to. You can just use it as a instead of saying the C symbol to indicate copyright, you can use different types of it to tell the public which level of copyright you're giving away. So there is one which is called the Creative Commons CC BY, which is attribution, and it says that you have to give the creator the credit, but as a user, you can reuse the material, you can edit it, you can use it for commercial or non-commercial things. You can even put it in a different type of license. While there is the SA one, for example, it also gives it gives the user all of the rights, so they can reuse the material, they can put it on their website, they can edit it, but they have to create the creator, and most importantly is that if they create something based on that initial material. So for example, if you have a paper and there's an image and someone and you put your paper as this type of license, then the user, I can go and take that image, I can edit it, I can add stuff to it, and I can use it in another way, but I have to credit you for creating it, and I need to I can't put more restrictive license on it. So it has to be the same level of the license. There's a number of other types of license, but one of which is the non-commercial. So you would say, okay, I have my work open access, is anyone can use it, but you can't and anyone can reuse it the way they want, but they can't make money out of it. So it is non-commercial use. The different ways of how to designate that level of giving away your copyright. So it's important because when you go on, either you are generating materials or you are reusing other people's materials, you need to make sure that you are working within the rights of those people, and you give them the credit that they deserve, and based on the license. So what I thought would be is to give you an example of an open access article. So for example, pharmaceutics, MDPI is the publisher. Pharmaceutics is the journal, so they have a number of peer-reviewed journals. They all are open access, which means that if you are the author of the work and you've written the paper, you want it to be published in that journal, you have to pay. And I think for this journal, they have it's in Switzerland, so they have, I think, about, I don't know, is it 1,000 Swiss franc or something like that? So as an author, you have to pay. The reason that there will be, depending on research and whether people go open access or subscription model, is that if you have the money to pay open access, you probably will go open access, so that your research is widely open to everyone. Everyone can access it without needing to pay. Also, there are research where the research is funded by public money. So, for example, in the UK, a number of ways that research is funded. One of it is through research councils, which are public, so it's public money. And they have now more requirement for work that is funded by them to be available to everyone through open access. So they provide, as part of the funding, the cost to pay for open access fees. So you can see for this paper, for example, the authors have put here what is their copyright. So if we zoom in, you can see it, that they clearly indicate the type. So it is Creative Commons and it is BY. So it's the attribution one, which is the most open one. So it means that you have to credit them, to say that they are protected, they've created that one. And they can, other people can use the information there, so you can use the materials, the writing. If there's images, they can reuse them, they can edit them, and you can even use them for a commercial use. So that's an important thing when you are taking materials from such journals and you're using it for your own work, for example, and you're creating an abstract, you're creating a poster. You need to be clear and careful about what is it that you're using it for. If it's a commercial use, which means that you're making money out of that material that you're producing, then you need to make sure that the license covered that. An important aspect of all of the protection for intellectual property, copyright, is that having the right, it doesn't mean that people are fully, how I say it, it's a way to prevent people from infringing on your copyright. But there's also a way to implement it, but it means that you need to fight. So if someone use material which is copyrighted by another person and they don't credit them, or they don't use it in the right way based on the license, then the person who owns the copyright, they can fight them back and then take them into a legal battle, and then but again, it depends on how much money it's going to cost for fighting that. You see it a lot in the art, so creative artwork. Let's say, for example, songs. There've been a number of, if you look in on the internet, you search, you'll find a number of cases where someone created a song, the lyrics and everything, and then another artist to say, oh, you've used this, it's similar to mine, you've infringed on my copyright, and they take them to court, and then they have to prove that they each side they have to prove their case. So it can take into, because you can think about it, if it's creating like materials like songs, there's money behind it, so you want to make sure that whatever commercial use is being accredited and giving money for it. Also, if you take materials from books, you have to request permission. So the way to request permission from the copyright owner, so for example, if it's open access and material and it is by this type of protection, you don't need to request permission. You just need to you need to credit them. So you need to say that this work is taken by this and it is open. If it's something which is a restricted copyright, you have to request permission from the copyright owner. I'll give you an example. So let's say you're writing a review paper, and in that review paper, you are using example from one of the research papers that you are citing. So as an important thing, you need to cite it. But if you're using, so you cite it, so you do referencing, as you've learned about how to reference materials. But if you want to use, say, an illustration that was in that paper, in your review paper, then you have to request a permission. It's not enough to reference it. You have to request a permission from the copyright owner. And you look at that, is it someone who is it the publisher? So you need to request that, and you might have to pay for getting the permission. Or if it's an open access and the material and the copyright license allows you to use it without asking permission, like the Creative Commons attribution one. And then where are you going to publish your review paper? You could be publishing it in an open access journal. So you can see, it's non-commercial. So you want to make sure that you select the right license for your work based on whether it is commercial use or not, for that image or that illustration that you took from that paper. So you need to be kind of a bit mindful and careful when doing that things. Usually publishers will not allow you to publish things if it infringes on other people's copyright. So they will, at the editing stage, they will come back to you and say, you don't have the permission for this material, we cannot publish it. But it's to save you time and to make sure that you'll be able to publish work, is to be careful about the copyrights and what it means. So you can tell now that you have idea about the copyright of written work. How about things which are not written? Songs, artwork, and all of that. These are not something that you can patent. Okay. Papers that you write, books, these are not things that you can patent. They're protected by copyright. If something that can be patented, it has certain criteria. And as the UK Intellectual Property Office describes it as being new, can be made or used, and needs to be innovative. And defining innovative is that something that is it's not easily thought of. It has to be something that completely different, not anyone can think of. Okay, something completely new. It's not modification of something already exists, and it's something that can be made. So you can say that you're producing you're making an engine, for example. That is something that can be made. If it's new, if it's innovative, then you can patent it. And you need to be careful, what is it that you're patenting? So you can see products can be patented a lot with the materials that, if you think of the pharmaceutical industry, they patent how they make a specific API or how they make a specific formulation to protection for that patent. And each dosage form will have its own protection. So they protect, for example, you can patent the tablet form of a drug. So you have a new drug and you patent the tablet form. Then they can do a capsule form, and then they patent that. But it has to be new, it has to be innovative. So there are different things that can be patented, but it is a very, very expensive process. People usually use patent attorney for it. And researchers who work on new novel ideas, they could generate materials which are patentable. It can be patent. But if you make it, so you provide your protection that you can commercially use it. If it's not protected, it means someone else can come and use it and generate money from that. So it's a good way sometimes to just go and look into different patents. So for patents, it could be you have applications. So once you apply for a patent, the application will be made available to the public. So you need to think carefully that that's a disclosure. So if you disclose it, then it becomes, if it doesn't pass, someone else might already have it. And then once it's, if it passes, that's the Intellectual Property Office says, yeah, it grants it a patent, and then it becomes a registered patent. Is also something that you can search for. So if you have an idea or something and you're doing research and you think this is new, it's solving a problem, it's innovative, people not necessarily think about it straight away, then you want to see if other people already have patent for it. So you can search, for example, the ones in the UK, which covers patents in the UK, and the one that covers in the US, and then in the European Union. And you can search for it. I thought to just to give you a screenshot, which is an example of what patent applications might look like. So you can see, for example, maybe yesterday, a company, Rolls-Royce, submitted an application for a patent for their for an engine, which is gas turbine engine, for example. So that's in the public domain, and you can see it. So it is patentable because it is something that can be made or used. So you can't make a picture, you can't take a photograph and you say, I want to patent that. It's not patentable. It's protected by copyright, but not by patent. In research, we have a lot of people who work and generate new ideas. They can protect it by IP. But as I said, this is very expensive. Sometimes universities don't have the money to protect it, and they need to be careful that it's not in the public domain. So if someone who is doing research, so is studying, doing a PhD, they have researched a new way of making a new formulation that is not easily thought of. And if they go and present an abstract, that's it. They can't go back and or a poster, they can't go back and apply for a patent for their work because it's already in the public domain. They disclosed it, or maybe in a meeting, open meeting or something like that. So it's important when thinking about protecting your intellectual property is to know that any disclosure, maybe even talking to other people about it, can eliminate your chances of getting an IP on that. And also, if anything is in the public domain, that's it. Cannot be patentable. Can be protected by copyright if it's a paper, but it's not patentable. Okay, so I think it might be a good time to spend more time on the problem-based scenario. But before that, if anyone has any questions, what we covered, I focused on the copyright because that's something as we either generate research output or we use research output, like we go into conferences and see abstracts on, you might be tempted to take a photo of a poster and then maybe reuse it. You need to be aware that that is protected by copyright, and the author or the presenter has their right for that. The same if you go in for someone's presentation and you might take a screenshot or something from it, you know that this is protected by copyright. It belongs to the person who generates it, and then you can't reuse it without their permission. Same with papers. We looked at how publications, peer-reviewed publications, are protected by copyright. It's different who owns the copyright. So if it's a subscription model, the publisher owns the copyright. You can't reuse materials without requesting their permission. I said, it's like if you're using information, you can just reference it, but if you're using materials from their illustration graphs or whatever, you have to request for their permission. If it's an open access, you need to be careful in seeing what type of permission was given by the copyright owner. So is it just to be able to use it for commercial and non-commercial use, or you can't use it for commercial use, for example? There's a restriction. So it's important to know about that. For patents, we just talked about it to understand that it's one way to protect someone's creation, and that is, it's not just an idea. So for example, you can't patent a mathematical way of solving a mathematical equation. It needs to be something that is can be used and utilized. It's different. The software is different. There are some softwares that can be apps, they can be patented, and others cannot be. So it depends. And that's why you have people who are specializing in IP. So they study law and then they go into IP side of the law, and it's this very big area of practice. But it's important to know that, and that you might need to seek advice whatever you're doing. So this is just a summary of what we've covered. If anyone has any questions, because I think it is good for us to have more time on the problem-based scenario, because it's so if anyone has any questions, please feel free to put it in the chat or to ask it directly. Anyone with any questions? So I give you time for that. So all feel, we'll see. I think we see once we go through the discussion of the scenario, if things are kind of clear, or if there's things that it's not, they've been not clarified. So just I'll go quickly through the problem-based scenario. So a problem-based scenario, for example. Okay, so it can be a real situation. So if someone who is in a position generating new material.
Dr. Barnes, are you giving us the intro before we go into our groups?
I think that would, yes. So I will go quickly through the intro of the problem based, and then if it would be great to go for into groups, maybe for 20 minutes or so people have time to discuss. Brilliant.
Okay.
Thank you very much. Excellent. So the scenario is based on something that can actually happen. So I put it as a way of someone who is an international students, and they are in the UK, because this is a kind of the environment I know. And you can have different things. So someone who is funded by their own government, so the scholarship, but also they work as a part of a research lab that is funded by by a UK government grant from research, and they generate images. So it's who owns the copyright of those images? Can the student use it themselves? And then the research itself. So you have the images and you have the output from the research itself, from the project. There's someone else is working on that project. Who owns the copyrights, who owns the intellectual property. So we know that there are two different things between the copyrights and the intellectual property of the work itself, not for the written material. And you have the supervisor, how much of rights do they have? Okay. Okay, so if we go now into different groups and into breakout rooms, and then maybe discuss the scenario, and then we come back and talk about it.
Okay, thank you very much, Dr. Boans. So we will go into our groups now. Yep. And in our groups, we will just get somebody who will take the notes and who will report, and then we go straight into discussing the scenario. And yeah, so IT, can you put us in our groups now, please?
Francis.
Oh, hello.
Hello, how are you?
Yeah, I'm good. Thank you. How are you?
I'm good, thank you. How are things going?
Yeah, cool.
Yeah,
I-
see,
I've actually been running around. I just came to see how things are going.
good. Yes, that's great. Yeah.
And I'll be leaving again soon. But yeah,
Yeah.
thanks
Yeah.
for organizing this.
No worries. I hope that will be useful for
Yeah.
everyone attending. Yeah, I moved near you now, so I'm in Greenwich in university.
Have you started?
Yeah, I started. Yeah, but I haven't been in the. I think I went yesterday and I saw by chance I saw Sue.
Oh, okay.
Yeah.
But you are in UCL office.
I know. No, it's the image.
Oh, okay. Yeah. So when are you coming to campus?
I come like a few days. So I came yesterday.
All right.
I drop in next week. I think there's something next week, like a meeting or something, isn't it? There's so just drop by. I'm doing more of the kind of.
Okay. Okay, go ahead.
Dr. Boans, let's go ahead.
Yes.
Yeah, I think he has resolved it.
Great. So how would you like us to go? To go team by team? So
yes,
okay.
Maybe 2 minutes per team is fine. Yeah.
Sounds good. Yeah. So if we start by team one, if you would like the representative of your team to give us a summary of what you've discussed, and we came up with like a 2-minute summary, that would be great. Thank you.
Mark.
Okay, thank you. I forgot we were group one. So we identified the main actors here to be Jade, Sana, the grant institution, and the supervisor. On the issue of copyright, we believed Jade owned the copyright.
Okay.
Once he's working in the university, he may also want to refer to the policies of the university with regards to copyright. And then he's also supposed to reference the university when he needs to showcase it because it was generated through their labs. With regards to Sana, we agreed that she doesn't own a copyright, but if there are administrative processes to follow, like referencing the owner or ensuring that you acknowledge the owner of the content, then that could be done. And the supervisor, we believe, does not have a right to patent whatever results comes. The right would be mainly the reserve of Jade because it's the one who generated the results. We acknowledge that the research institution providing the grant would also be a stakeholder, and so they need to be acknowledged, and where there's going to be any profits or gain, they must be consulted and involved. This is a summary of what I...
Right. That's great.
Yeah.
Perfect.
Yeah.
Thank you very much. Thank you, Mark. And thanks for your group. I wonder if group in room 2, if they would like to provide a summary.
I'm not sure my group number, but I will just summarize for my group.
Okay.
So we thought that Jad was the one. In fact, there were two schools of thought. That one was that the institution owned access to the copyright because it's the institution's system through which Jad was able to generate the images. Another school of thought that the Jad owned those copyrights, but clearly we agree that Jad had the IP rights, and therefore if Jad is publishing with Sana, then probably it's a straight away usage of Jad's own image. But the PI, principal investigator, copywriting or patenting the work may have to be in conjunction with Jad because he generated it, we also thought in another school of thought was that the institution owned it because the institution is the one who funded it. But then we also thought that, I mean, would they have the right to deprive JAD of the intellectual property, because it's intellectual property. So can you strip it off the employee because you are the employer? So that was a question we didn't answer.
Okay, cool. Sounds good. Thank you very much. Thank you for the summary. And we'll look into the question as we discuss it at the end. Thanks for you and for your group. Team 3. Okay, they were in room 3, or the room that is not the last speaker. Anyone would like to? Yeah.
I presume that will be my group. So
okay.
For the first part of the question about who owns the copyright, the team agreed that it was JAD that owned it because she generated the images. About the question about how can she obtain permission to use the image in the competition, the team agreed that, well, she'll have to contact the institution if she would want to do something like that because she generated it through their labs. Yeah, unfortunately, we were not able to complete the rest of the questions, but that's how far we got.
Okay, brilliant. Thank you very much, Norris. We'll go through the rest of it at the end. I think the last team.
Okay, so I'm speaking for group 5. Yes. In fact, I asked the question whether we should do the separate scenarios or we should do them together. So our discussion was based on the various scenarios. So for the first part of it, based on the information that is in the first part, we agreed that JAD owns the copyright, and that he's in UK, and in UK you don't need that permission to use the knowledge or the pictures, and so he didn't require any permission from anybody. But going forward to the other paragraphs, we realized that there are no copyright issues if JAD is using this document. There was also another thought that once he's working, the information given us tells us that the UK government is funding it, and then the principal investigator also on the grant is a different person. They will have to seek permission before they use the images. Now that we have been told that the PhD funded by UK Research and Innovation, and then together with the principal investigator. Then the second part of it, what does Sana has to do before submitting the manuscript? We said that he has to get permission and state a source of funding and everything for the work that he's presenting. For the paragraph 3, we are saying that the principal investigator and funders of the project own the IP rights because they all contributed to coming up with the whatever came out of the research, and the supervisor patenting a part of the work he will also have to seek permission from the funder, which is the UK government, so that he will not breach any of the copyright rules. Thank you.
Great. Thank you very much. Thank you and for your team. Thanks for the summary. Do we still have one more team? I think is we heard from 4, right? So I think, or not.
I think we do have one more team, but I'm not sure
if they have a
who is it.
representative. Yeah.
Yeah.
If it's okay, yeah. If you have a representative from that team that would like to give a summary, that would be great. Otherwise, we can go through the. I can go through the scenarios and commenting on your summaries. Okay, right. So it's really good that to see that you all thought about the different players in this scenario and their connection. So it's important things, and I think the key thing is that you can see how complicated it is and can lead to issues, real issues. So the key thing is to differentiate the copyright from the potential patentability of a work. So the images are they are under copyright, and thinking about what is the relationship of each one to the other part. So you have Jad is a student, so it is relationship to the university and the funder that it is that he's a student. In the UK, PhD students are not employees, so they don't have the same responsibility for the university, so they're not employees. While the postdoc researcher and the PI, they are employees. So something important is that if any intellectual property generated during your employment, if the employer owns that, if you did it as part of your work. So that's an important element, which we didn't talk about during in the slides. So if you are self-employed, everything is you generate is you have the intellectual property for. But if you are employed, then your employer have that, which means that the default for the copyright is that for the student, they own the copyright. So Jad has the copyright for the images that they generated, so they can enter the competition because they own the copyright and they don't need to ask someone else. They can do it in a way they can inform their supervisor, because it's important to think of other things. They take their permission not because they own the copyright, but because it could be that the supervisor is thinking of other things to do with the results. You have for the publication. The publication is kind of because of as one of you said, is about the acknowledgement where the funding is coming from, and also deciding. So what Sana can do, she can use the images that Jad produced because he will be an co-author on the paper, but they need to make sure what is the who will own the copyright of the publication. So where are they taking their publication to be published in? Is it going to be through a subscription only model? So they will not be paying anything, but the publisher will own the copyright, which means that they will own the copyright of the images. And or they are going open access. If they go in open access, which one of the Creative Commons license they will go with? Is it something that you can use it for commercial or non-commercial use? The other element is where the patenting of any potential creative, innovative part of the research. So all of those involved in the research can be innovators on the patent application. So the PI and the students and the postdoc, they all can be innovators. And by default is the university who owns the IP. And then that is kind of the default, unless there is a contract between the study started between the funder and the university. And that is usually the case. So when a PhD student starts with their study, depending on the paperwork that they start to sign, is signing intellectual property. So by default, they own their own intellectual property and the copyright, but it could be that they sign waivering that to the university. And if they have a funder, then usually the funder will also need a contract with the university stating clearly who owns the copyright, who owns the intellectual property. So if there is something innovative comes from the work and they want to patent it, then it's clearly it is clarified who owns that. If there is if that wasn't signed, then the default, and again, depends on the situation, and that's a kind of legal thing, but it's usually the university that owns it, because it's the employer of the researchers, and the PhD student owns the part, the intellectual property of the part that they generated. An important implication of putting things in the public domain, because the PI is thinking about patenting part of the work, so they need to do it through the university. The postdoc doesn't really have much of any rights because they are an employee, so everything they generate belongs to the university, and the same with the PI. So they have to do it through the office in the university, and reviewing the contract they had or the agreement with the funders. But important element is that if JAD goes ahead and put the images in the public domain, it could jeopardize the chances of getting a patent from for their work, because it could be that they put something out and that makes it in the public domain, and they can't really patent the work afterwards. So it's important, and the same with the publication. So they need to make sure that they decided on whether to go ahead with the patent or not, with the work with the patent or not, before they put things in the public domain, which is the images in the competition or the papers for the publication. So I hope that's kind of clarified it, and pretty much you've got a lot of it in different groups in the right way. But it's important to see how much rights the university or the research institution has, because it's the employer. And then thinking about the funder, did they assert their intellectual property right or not? And then usually the default with the student that they own whatever they generate, they own the right to it, and the employer don't have any. They don't really anything you generate it belongs to their the employee. Anything that generates belongs to the employer. So I hope that kind of made sense and answered any questions you might have about that. So, but anyone has any questions?
Yes, there's a question in the chat box.
Oh yeah, someone is asking about so pharmaceutical company, which is AZ. Yeah, exactly. So that's why that is a good question. So they won't go into that. The student can, if the research is done by a student, they could have the intellectual property for that, and then the fund. So that's why they will not go into any start of research before signing an agreement. So if the funding is funded by whatever the funding body is, even by a foreign government or scholarships, or they all have to sign clearly what is the who owns the intellectual property from that work. And I know some PhD students, when they start their PhD, they don't feel like it's important thing. They sign off their intellectual property rights. But then as they progress, they might lose that. So companies have their own office, specifically people working on that type of paperwork. So you can't do anything in collaboration with them without things having been in writing of who owns it. And universities as well, so they have their own contracts clearly between who owns what. I hope that.
Thank you. I think we have a hand up.
Oh yeah, Samuel, please go ahead. Someone.
Thank you. Incidentally, your answer touched on a response to my question. As you rightly pointed out, and we have also learned, this is a very complex area. And then I like the part that you said from the outset, there may be the need for contracts relating to, intellectual property rights to be signed, especially, with respect to the funding agency, the university. I think they are very, very important.
Yep.
Otherwise, when issues, come up later.
It becomes very messy, isn't it? It becomes
can be very, very
yeah.
messy.
Yeah.
But at least my take home is that this is an area you don't have to toy with. And also, we are here learning, probably to enhance our chances of, doing some publications.
Yes.
So we need to take these issues very, very seriously.
Exactly. Exactly.
I honestly, I didn't before this meeting. I didn't consider. I didn't consider this subject as this complex, but it's a very good learning experience. Thank you.
Thank you. Thanks. I'm glad that it was useful. I think there's another hands up. Ozzy?
Yes.
Pharmacist Osesibe, please go ahead.
Yeah.
Yes, please. So I am bringing it down to our level here as student of the Ghana College of Pharmacists. We are going to undertake some research work.
Mm-hmm.
And so in this sense, whatever we generate out of the work we do, who owns the copyright or the intellectual property rights of the work as we do as students of the Ghana College of Pharmacy?
That's a great question. I think it's important to see what is the local guidance for that. And because there should be something in writing about who owns what in terms of that. And if it's not, there's no local guidance, then should be a national guidance. So something about in the country about the intellectual property and who owns intellectual properties and including copyright for materials generated, because it's not just the it's the research is one thing where new things are generated. You have production of different things, and all of that is covered or protected by IP law. So it's important to see what it's locally. So if it was something in the UK, for example, would be so I would say you look at the university or the institution where that research is done, and what is the agreement where the funding is coming from, and what is your relationship to the institution. Are you an employee or a registered fee paying student or whatever that is? So I think it's important to look into it's something that's where the research is done. They must have a legal team that deals with these things, and they will be able to provide that information. But it's important to know that it needs to be clarified before the research takes place. So knowing who owns what and what type of protection for all the parties involved in the research. And again, I'm thinking again that also if you are doing a research involving human participants, that also adds another element of complexity to it. So you want to know what is the legal protection for that as well. Yeah.
So I'd like to add that there's a Copyright Act and in Ghana, so just so that people can look at it and look at the various aspects of it.
Exactly.
And also consult accordingly.
That's great. Yeah, because even each region or even each jurisdiction, they have their clear rules and laws about protection and copyright and in that. So it's something that's been for ages.
Yes. And so I can't see another hand up. And I just want to make an observation that we have about 6 devices that are registered to Giftineti. So it is likely that Giftineti registered and sent the link to other people. So it makes it a bit difficult for us to assess who has participated. And I'm sure that is why when I moved from room to room, there were quite a number of, unless it is one person who has joined many times on different devices, that's also possible. But I will encourage that in the future, we all try to use the link that we receive when we register, because that will give the name that we used to register. And it makes it easier for communication. And since we do not have any hand up, I'll ask if Dr. Boans, you have any maybe final comments, and then we've saved a few minutes.
Yeah. So I think the final things is almost like the final take-home messages is to know that anything that is generated has is protected, and there's a moral element to it as well as legal element. Is that you the one who generated something is being the accredited and as well as being maybe giving the rights of for that, so they don't have to fight for their right. It's like if they have it. If you think there are a lot of resources out there to learn more about a specific topic. So about copyright, you can look into Creative Commons license website. So just search Creative Commons, and then you can find all about it, especially if you're thinking of or you're working towards publication. It's a good idea to learn, because it's connected to the publishing models available, and the open access model is kind of again, it's just it puts the financial element or the burden on the author, but it gives the author the copyright, and then they decide on what they want to do with the copyright. If you're thinking more about intellectual property in terms of patents or registered designs, because that's also something that can be protected, then you can look more information on your local as well as international offices or websites. So you can look into the US patent office. They have really a lot of information. If someone is thinking about it, there are a lot of patent attorneys are the kind of specialized area of law practice, and in the UK probably can put in the website for registered, even though if it may not be relevant, but registered patent attorney in the UK, so you can look and search for it. It's as it is part of practice of law. These are kind of expensive what they call it. It is expensive to kind of consultation. That's the word. So just be mindful of that, and looking at what is local, what is the information available locally. And I hope that you've found the session useful, learned new things, and learned about where to find more details about it. So thank you.
Okay, so thank you very much, Dr. Asma Boans. Thank you for taking the time and doing this research and sharing it with us. I believe that perhaps moving forward, because of the question, the last, I believe it was Pharmacist of CSCB asked, perhaps in a follow-up to this, we will get somebody who is versed in in copyright and patent law in Ghana, intellectual property in Ghana, to maybe discuss these things further. Then we will not only cover our research, but also maybe any other findings or any other creations we may be involved in, because I think that for most pharmacists, we are doing things other than, in addition, we are doing other things which may have some protection. And so I think that will be the next thing that we will do. But as Samuel indicated, this has really been enlightening. We have seen how complex this is and how important it is not to take these matters for granted, because it's very easy to say that, oh, I saw this and I just picked it up and I did something. So it's not just about referencing right, but it's also knowing how much you can use and for what. And so it's very enlightening, and thank you so much. And I will also use this opportunity to say thank you to all you participants who have so far been involved. Please, I'll ask that you don't leave, because in the next minute, we are going to post the evaluation, and we'll ask that you participate in that evaluation. Yes, so this is for this session. Would like that you evaluate that, just look at the questions which you've been given, and assess, do the assessment and submit.
Great.
And that is going to help us moving forward.
Great. And I would like to thank you for inviting me to present today, and for all of participants of their really for their engagement, because they were really good engagement, and for questions. Thank you very much. I really enjoyed it.
Thank you. We enjoyed having you.
Thanks.
So please, if you have finished with your assessment, your poll, please just go ahead and submit it. Just 6 questions in all. And thank you. So we will I'm sure for most of the candidates here, most of the participants are candidates or in some way linked to the Ghana College of Pharmacists. And so they are aware of the website. As we have done with our 2 previous sessions, we will put this also on the website and it will be available. Oh, Pharmacist Justice Dogbe, please go ahead. I see that your hand came up and went down. Pharmacist Justice Dogbe. Okay, so.
Hello, good afternoon.
Good afternoon, sir.
Yes, I don't know whether I'm the only one experiencing it. Whenever my line drops and I want to come back to the meeting, I will have to re-register again. I'm wondering why that challenge. Am I the only one, or others are also having the same problem? Thank you.
Okay, I want to believe you are the only one.
Okay, all right, thank you.
Yes, but I think that when you register, you receive a mail. So if the line drops, you just go to that mail, and that mail allows you to join without registering.
Okay, thank you.
Yes, you're welcome. Okay, so Yes, so thank you. Thank you for participating. Thank you for giving us your time, Dr. Boans. And thank you to all of you for being so engaging on the Mentimeter and also in the Zoom rooms. We know that in some rooms it took a few minutes for participants to warm up, but well, you warmed up and then you gave very good input, so that is great. Thank you very much, and we also thank God for this opportunity to be able to share as scientists. And so we'll meet again in our next session in May.
Great.
Thank you.
Take care, everyone. Have a great day.
Yes.
Bye-bye.
Bye.
Bye.
And thank you for being there for us.
Thank you.
Thank you. Thanks. Take care, everyone. Bye, everyone.
Bye.